Thank you for clicking this video. My name is Mujela Olua and this is Battle with Ola, and we want to talk about hire purchase and hire purchase agreements in Nigeria in this video. Hire purchase is similar to mortgages. It is similar to buy now pay later, something that is on the rise, gaining a lot of traction in Nigeria at the moment. But we want to talk about hire purchase agreement in particular because it's something that I'm familiar with as a lawyer and that I've had to deal, in and with in recent times. So I'm going to be providing an experiential, point of view, and we're going to be talking about what the law says and how it is in real life. So today let's talk about hire purchase agreement. As you already know, Battle with Ola as a consultancy, and whereby you pay me and then you get to speak with me one-on-one to discuss a legal challenge, and I prefer legal solutions we discuss together. A few of you have already explored that service, and I'm thankful for your engagement. I'm happy that I was able to prefer and discuss legal solutions, to your legal dilemmas with you. In the coming year, Battle with Ola is expanding to a document review and legal opinion. It means that if you have an agreement or you're entering into a contract and you'd like me to look at it, look over the contract from the lawyer's perspective, and provide legal guidance as to what your duties and obligations are under that contract and what it means and implies for you, as a party to the agreement or the contract. I would be offering that service at a fee. That's what it means. That's the document review. I'm not talking about the graduate application document review now. That's done under Houseoflivingstones, which is also, a registered business that Battle with Ola does. So this is legal document review. So you send me your document if you're entering into a contract, or if you're a party to an agreement and you'd like a lawyer's perspective. I always say that a lawyer's perspective, I always advise or encourage people to carry a lawyer along. Do not wait for something to degenerate into do not wait for things to degenerate into a problem before you involve your lawyer. Let your lawyer be involved from get-go. So if you'd like me to be that lawyer, you'll be able to, from now and until the coming year, going forwards, you would be able to send me your document. I would look at it. I would provide, a legal perspective, what it means, your duties, your obligations, and the implications of that agreement or contract before you go into it, for a fee, and also legal opinion. If you have a legal challenge and you'd like me to do a proper legal opinion documented, I would also be offering that service. So now we have the consultation which has different services where you can talk to me one-on-one. You can share, by email or by document. You can share your legal challenge with me and have me provide or a written legal opinion on it, or you can also and you can also send in your documents for a legal document review. So those are services under the consultation arm of Battle with Ola. If you look in the description box, you would find links, to use those services, or you can always mail me at houseoflivingstones@gmail.com, so that we can get started on whatever it is that you require. Thank you so much. So let's talk about hire purchase agreements. And happy that this particular topic is going to be like a build-up to the last topic. If you watched the last video, we talked about the differences between ownership and possession. So that's also applicable to hire purchase agreements, and you'll see why shortly. What's an hire purchase agreement? If you look at the Hire Purchase Act, if you look at Section 20, subsection 1 of the Hire Purchase Act, it talks about payment of goods in portions of an agreement under which, the bailee may buy the goods, purchase the goods, or under which the property or the title in the goods may pass to the bailee. So that's essentially what hire purchase is. So the bailee is the hirer in this context. The bailee, if you look at Black's Law Dictionary, it explains or interprets the bailee as someone who receives personal property from another, wherein he holds the possession but not the ownership. The earliest case in hire purchase agreements is LB and Matthew. In that case, LB, or Mr. LB, or let's just say LB, gave his piano to a third party. for him to pay in installments before he can own the piano. So the ownership is still with LB, but he has given the possession to that third party and says that, okay, pay me so amount over a period of time, pay it in these installments. And when the installment payments, when the payment in installment is complete, the title in this piano will transfer to you. And then that third party now pledged the piano to Matthew, in a different arrangement, a different transaction. So when LB heard of it, he sued Matthew, to repossess and recover his piano. And that's the court held that the third party that gave or pledged the piano to Matthew could not do that because he did not have a valid title to pass to Matthew. He only had possession because he had not completed the instrumental payment. So that's the easiest way for you to understand hire purchase. It's an agreement usually between two parties. It could be between three parties. We'll talk about that much later. The instances where it can become a tripartite agreement, but usually it's an agreement between two parties. For instance, I have this suit. You could make me an offer to execute a hire purchase agreement with me and say that, okay, give me your suit so that I can use it, I can wear it, and then I'm going to pay you maybe $15 for this suit, and I'm going to pay it in installments of $5 for 3 months, or say $3 for 5 months. So when making the last, or when I've made the last payment, I'm going to have the option to either purchase the suit outright or return it to you. So that's what an hire purchase agreement usually looks like. There's an hirer, someone that is proposing to hire, goods or property, and there's an owner, the person that owns the property, who has the possession and the ownership. That's why I said it's similar to that last video. So he passes his possession to the hirer until the agreement is performed, until the contract is performed, after which the hirer can now exercise an option to buy the title as well. But if not, the possession reverts to the owner. But if he buys, the ownership now passes on to the hirer alongside the possession. That's what hire purchase is. Now, in Nigeria, hire purchase is very, very common, although it's something that's less talked about, as I have observed, but it is very, very common, especially in the automobile sector. So for people who sell cars, who sell bicycles, who sell tricycles, who sell, all these automobiles, they have these hire purchase options for their buyers usually. So you buy, you pay in installments, and then at the end you can exercise the option of purchase. But if you default, something happens as well, which we're going to talk about. Now, this is different from mortgages. It's similar because it involves payment in installments spread over, a period of time, an agreed period of time, and it's similar to buy now, pay later, but it's different in the sense that for buy now, pay later, as soon as you make the first deposit, you are the owner, you take it away, and then you continue to pay until you pay in full. But for hire purchase, the distinct factor is that you only have the possession at the point of making an initial deposit. You do not have the title. The title only passes to you at the end of the final payment in installments. At the end of the final installment, the title only passes to you if at the end or upon completion of the installments, the payment in installments, you exercise your option to purchase. It is not an agreement to buy from the onset. No, it's an agreement to hire what the owner has with an option to buy at the end or the conclusion of the payment. So there are some distinct features of an hire purchase agreement or an hire purchase contract that I've already mentioned, but let's re-emphasize them. One is that the owner has the title, but the hirer gets the possession upon reaching an agreement and after an initial deposit has been made. That's one. Two, it's an agreement to pay in installments, and if the hirer fails to pay an installment, if an installment is due and unpaid, the owner has the option and the right to actually recall the goods, to take over, repossess his good, his valuable, his property, and the IRA stands to lose whatever installments he has made up until that point. So those are some of the distinct features. And like I said, it is not an agreement for outright purchase, except at the end of the payment in installments, the buyer decides that he or she wants to actually buy outright. So that's what an hire purchase agreement is all about. Now, the distinct features of the agreement itself are the usual features of a contract. I've done about 2 videos on contracts and features of a contract, the important clauses in a contract. Please watch them. But the features are, there must be, oh no, let's talk about the components first. The components are that there must be an offer, acceptance of that offer, an agreement of the mind, and then consideration for value, and then there must be capacity. So offer in the sense that the IRA will make an offer to the owner and say that I want to, hire your property, your car, your tricycle, your keke napep, your bike, your Okada. I want to hire it. And then there's an acceptance of that offer from or by the owner, usually the seller, and then or the dealer. And then there's an agreement of the mind. Both parties understand that this is not an outright purchase. I'm not loaning you, I'm not lending you, so to speak. It's not a buy now, pay later agreement. It's not a mortgage. It's an hire purchase contract. There must be a consensus addendum. That's the agreement of the mind. I believe I've explained that so many times on this channel. And then there must be capacity to actually enter into that contract. That is, both parties must be adults under the law, and they must be capable of entering into a valid contract. We've talked about people who cannot enter into a valid contract if you look at the videos we did on contracts. But there must be capacity. For instance, an infant cannot enter into a contract validly. So both parties must have capacity to enter into the contract they're about to enter into. And of course, there must be consideration. Consideration usually talks about the value that exchanges hands. That is, I'm giving you my car. What's the value you're giving me in return? That's payment, an agreed sum. That is installments, payment in installments. Okay, the keke napep is 1.3 million naira. I will pay an initial deposit of 300,000 naira, and then I will pay 200,000 naira over a period of 5 months, or 100,000 naira over a period of 10 months, at the end of which I have an option to actually purchase the keke outright, and at the end of which, or upon the default of which, you can also repossess this keke from me. So that is there. So those are the essentials, the components of the hire purchase agreement. And now let's talk about the obligations of both parties under the agreement. Like I said, the owner has the title and the IRA gets the possession. So the responsibilities or obligations of the owner under an hire purchase agreement are: one, he has the goods, the ownership. He has a valid title. He must have a valid title to pass. If the IRA intends or wants to, buy at the end of the transaction or the payment in installments, he must have a valid title. Before he can even pass the possession, he must have a valid title in the goods, or in the goods, yes. Then he has an obligation to deliver the goods to the IRA. So it shouldn't be that after the IRA has made an initial deposit, the owner will abscond with the payment that's been made and the goods they've talked about. If it's a car, for instance, let's use the car. Maybe I'm hiring a Toyota Sienna and I want to use it, for certain purposes, and I've reached an agreement with the owner or a car dealer. Usually it's a car dealer or a seller. So he must deliver that Toyota Sienna to me. That's his second obligation. The first is that he must have a valid title. He must own that Toyota Sienna. He must be able to properly and validly sell it. That's one. Two is that he must deliver the Toyota Sienna to me after I've paid my initial deposit and after we've executed the contract. 3 is that you must deliver that Toyota Sienna to me in the condition in which we described it. So if I have said that, okay, I need a Toyota Sienna with certain number of tires, with these specifications, a radio in the car, tinted glasses, one large wiper instead of 2 wipers, so many things, specifications. You must deliver the goods according to the specifications that we have agreed upon and that is in the contract, specified in the contract. In the olden days, hire purchase agreements were reached orally, but these days, and especially under the Hire Purchase Act of 1965 now, it is documented, and it's fairer now because both parties we must understand what they are signing and have copies of what they are signing. That is the fair dealing now. So he must deliver that Toyota Sienna to me in the condition that we agreed. He must deliver the agreed upon specification to me, the particular goods that I agreed. Not that he will now bring me a Hilux Jeep. No, he must bring that Toyota Sienna that we agreed upon and deliver it to me, or provide it for me to take delivery of it. That's the third. And the fourth is that he must actually deliver it in a fit and quality condition to me. So it shouldn't be that maybe the absorber is bad and I've not been told, or maybe the fuel tank has a problem and it's leaky and I've not been told. No, he must deliver it to me in a fit and a quality condition. And the last obligation, there might be several other obligations depending on the kind of goods involved and the agreements reached by both parties. The important thing is agreement of the mind. So if you're adding any other flavors, the important thing is for both of you to agree. But the final thing is that you must deliver quiet possession to me. That means that I won't get the Toyota Sienna, hire it, and today one debtor is saying, now Mr. Lagbaja owes me, so I want to take it back from you. Another one will say, oh, it's not Mr. Lagbaja's car, he stole it from me, so we are taking it back from you. Or maybe police will now be inviting me and saying, come and explain to us how you got this Toyota Sienna, we've been looking for it. No, so that's why all those other obligations, they must be fulfilled. And the final one is that I must have quiet possession. Must deliver quiet possession to me. Just like as in property, we talked about ownership and we talked about possession, that the landlord must deliver quiet possession to the tenant. So I must be able to enjoy that Toyota Sienna for the purpose for which I've hired it in peace and quiet, without any disturbances emanating from the owner's side. Those are the obligations of the owner under the hire purchase agreement. Now, what are the obligations of the hirer? If I'm the hirer, for instance, what are my obligations? First obligation is an obligation to accept the goods. So after I've made my deposit, after I've executed the contract, made my initial deposit, we've had an agreement, I should take delivery of the goods. So it shouldn't be that it will now procure the Toyota Sienna and then it will be waiting for me for 2 years. I will not come and take it, and we have a pending contract, No, I should take delivery of the goods. Whether I'm going to go take it from a shop or you're going to make an arrangement for him to deliver it to me at an agreed location, I must take delivery of the goods. That's one. The second thing is that I must take good care, reasonable care of the goods. So the safe thing that I would advise a client entering into an hire purchase agreement is to use the property or the goods as if you are the owner. How would you care for your own Toyota Sienna? That's how you should care for one that you've hired. There was a case I was involved with, and the real reason, apart from default in payment, why the owner decided to repossess the car and to now offer it for sale to a third party was that this hirer was not using it according to the purpose that they agreed upon, that is signed to, and he wasn't even using it in good condition. So they also, the dealer, or it was a finance house actually. So the finance house was working with a dealer, and that's where a tripartite agreement comes in. So I said there must be two parties. In some instances there are three parties. So there's a finance house that you approach for an hire purchase agreement. So they'll be working with a deal. So they'll be working with a dealer. So if you wanted to buy a car, hire purchase is very common in sale of automobiles. It's also useful in other goods, sale, purchase, and hiring, but it's usually more notorious in the automobile circle or industry. So for instance, you want to buy a car, so you could approach a finance house. They would have a dealer they're working with, who would provide the car, and then they would undertake, they'll be your insurance with the dealer. So you will be paying to them and they will be the one paying to the dealer. So they will be the one that executes a contract with you, and in the process or in the case or the instance whereby you default, they'll be the one to handle everything. The dealer will just be, in the background, So this is what happened in this case. So they even had a quality control officer, and I've forgotten, the officer had a title, someone that could drop a plan for you and tell you that, okay, you want to hire a Lux Jeep, for instance. You want to use it for transportation. It's not the best. Why not buy a bus, a Sienna bus, or a Toyota Hiace? And then they will tell you that this Toyota Hiace, the one we are providing for you, this is the mileage on it, this is how far it can go, this is how you can make the most of it, get the best of it. If you carry so passengers and use it to, transport in this particular route, this is how much you will make, and this is how you'll be able to pay us back over this period of time. They will do a forecasting for you, a perfect smart job. And so in this instance that I'm referring to, the IRA had not used it according to purpose. So he was planning a different route from what they had agreed and what they had advised him. And so he wasn't making enough to meet up with the payment. So he was defaulting. The car was developing faults because it wasn't being used according to a perfect forecast, that could have been beneficial to him. So they had to recall and repossess the car because he couldn't meet up with the payments and everything. So what I was driving at that made me give this example is that you should take reasonable care. The IRA has an obligation to take reasonable care of the property. Let's just keep using automobiles, for the purpose of this video, of the automobile. So of the car, the IRA should use it the way he would use his own that he bought with his money and with his sweat. So use it like that. That's the best way. So that's a duty. So also a third duty or obligation that the IRA has is to pay for damages where he has damaged the car, the automobile, So if they are recalling it upon default, or if at the end of the contract you're not exercising an option to purchase, if you've damaged the car, you would have to pay for the damages, and those are damages that it's been ascertained that it was caused by you. So damages that are maybe normal wear and tear, that maybe an act of God, maybe a fire, an accident. We'll talk about that much later or soon. Those ones you won't be responsible for it. But if the owner can ascertain, and I know that people who do hire purchase, they have people, officers, they have their names, their roles, that will check these things for them and say that, okay, this person couldn't have caused this. And they'll ask you questions, of course, they'll interview you. Some even monitor the car. Like the one I spoke about, they had, I think, a mileage monitor in the car that they could monitor back at the office that could tell them that, okay, we told this guy to ply between Ore and Benin, and now he's plying Ore to Warri, Ore to Warri, Ore to Warri. Ore to Warri is farther than Ore to Benin. So you know that the mileage will be more, and there'll be more wear and tear if the road is bad and whatnot. So they had that, So that's their own peculiar arrangement. Anyways, that's not how it always is. But what I'm saying is that if there's a damage or there are damages at the point of return, the IRA has a duty to reimburse or pay for those damages. The IRA also has a duty to pay its installments as due. Installment payment and breach of payment is usually what causes fights for most hire purchases. And because the way that the hire purchase agreement or hire purchase business or concept is structured, it favors the owner more, in the sense that there's usually a termination clause, and one of the most powerful and the clause that is always invoked at the point of terminating the contract is that the IRA did not pay the agreed installment. If an installment falls due and it's unpaid, the owner has the right to repossess the property. So owners are usually more gracious one than the other. So some might give you an extension, some might not give you an extension. So in the case that I refer to, for instance, they had given him different extensions and he couldn't even meet up because of the way that he was using the car and because of not meeting up to the income that he could have got or gotten if he had used it according to their advice or specification or agreement. So if an installment falls due and it's unpaid, the owner has the right to repossess and the IRA might lose. So the fourth duty of a hirer is a duty to pay installments as due. Another duty that a hirer has is a duty to redeliver the goods or the car, for instance. So when you've paid all the installments, you should return the car to the owner. And if you want to exercise an option of purchase, let the owner know so that you can execute an outright sale agreement, because it's different from the hire purchase agreement. So it's hire purchase because you hire first and then you have an option to purchase, but it's not purchase, outright purchase, until you have exercised that option to purchase. So let's talk about the most important features or clauses in an hire purchase agreement. So if you're entering into an hire purchase agreement, you should look out for these clauses, because in a case that I was also involved in, one of the excuses or the things that the hirer insisted upon was that he did not understand the agreement to be so. That is, did not understand or he did not know about a particular clause for repossession. And they showed us the contracts that he signed. Those things were in the contract. So ignorance is not an excuse. That's why you need to get a lawyer to look over an agreement for you before you sign that agreement and before you, go ahead with it. So these are clauses you should look for. General clauses, and that's the title clause, the name of the parties, the place of the agreement, the subject of the agreement, and the description of the subject and the date, that the agreement was executed. Of course, you should look at that. Very important. All those things should be there. There are general clauses. They are applicable to all contracts. And of course, you should then there should be a recital clause. The recital is going to describe the property and describe the interests that both parties have in that property. That is, so person, the owner, is desirable of transferring possession to so person, the hirer, who is willing to hire it for this particular amount to be paid in installments of so and so over a period of so and so. All of that should be in the recital. So there should be a recital clause that will describe, what is bringing both parties together or all parties together, where the parties are more than three. Then the dispute resolution clause is very important in any contract. Dispute resolution clause, if there's a default or if a party wants to pull out or there's a dispute between parties, how do you settle it? Do you go to court straight or do you employ mediation, arbitration? So whatever. Usually it could be factored around the value of the goods. So if it's you're hiring a ship, for instance, now, you would want to explore, some means of settlement that will be different from if you're just hiring a bike. So a dispute resolution clause, very important. And then there must be a termination clause. This is the most important clause in the hire purchase agreement, a termination clause. How will this agreement be terminated? Now, usually there are different means of terminating an hire purchase agreement. I think the first and the most important termination means of termination is by performance. So if the contract is performed, when the performance comes to an end, it's terminated, and then you can exercise your option of purchase or option to buy. So as an IRS, so performance is one of the means of terminating the contract. It just means that both parties fulfill their obligations to the very last. That's one. Then termination could also be by repudiation. Repudiation just means that one party pulls out and says that I'm not doing it again. So you factor this into the termination clause too. If a party says that they are not doing it again, do they lose something or do they gain something, or does the other party gain something? You should factor that into your termination clause. the hire purchase agreement can also be terminated by a judgment of the court. So the court can make a decision if both parties find themselves in court, or if another party takes them to court or litigates in a way that relates to the subject matter. It can be the court judgment can bind that contract and terminate it. So a judgment, a decision of the court can terminate the agreement. Another means of termination is by frustration. Frustration means that the subject matter is destroyed in most cases. For instance, there could be a fire accident, an act of God, a flood, something that is not within the contemplation of both parties and is not the fault of either parties or all parties in the contract. So if that happens and the subject matter is destroyed, the contract stands terminated, and whatever obligations any of the parties have afterwards is discharged. And then there could be an option to buy and an option to return. So the contract can also be terminated by an option to return the goods. If certain conditions are met or if certain things happen, the IRA has to return the goods. If there's a term or if there's a stipulation like that and the IRA decides to exercise, that option to return, the contract stands terminated. And of course there could be an option to buy too. So where the IRA has completed payment, it can exercise an option to buy. It could buy. When it buys, the contract is also terminated, and then a sales contract is executed in place of a hire purchase contract. So a termination clause must include the conditions or the instances in which the contract will be terminated or stands terminated. Very, very, very important. If you're an IRA or if you're the owner, pay attention to the termination clause. Have your lawyer give you a comprehensive understanding of all the various incidences of termination that could occur or that you're signing to before you sign. Very important. Usually it would also include that, for instance, what most IRS usually suffer is that if the termination is coming as a result of a fault of theirs, they would lose whatever installments they've paid up to that point. So a hirer is usually crying wolf and saying that, oh, that's unfair, so all the money I've paid. No, look at the contract now that you're signing it before you cry wolf much later. Very important. Have I mentioned the consideration clause? That's a very important clause as well. It must be stipulated the total sum, the installments sums out there to be paid over a period of time. So that should be stipulated. The initial deposit and all of that must be stipulated, consideration clause. And of course, the responsibilities and duties clause, very important. So a hire purchase agreement must stipulate the responsibilities of the owner and the IRA. Very, very important. So those are some of the important clauses. There are other clauses, but those are things that you should pay specific attention to if you're an owner or if you're an IRA. Very important. So some closing remarks. Very important that you should pay attention to these things. One, make sure you have a copy of the agreement you're signing. Gone are those days whereby it's just the owner that has a copy. If you're an IRA, your interests are at stake. So make sure you get a copy of the contract. Have your lawyer interpret it to you before you even sign. And after signing, keep a copy in case an owner wants to be duplicitous and maybe they want to change some things or act funny later. So keep a copy of the agreement. That's one. Two is that if you're an IRA, have it at the back of your mind that if you default, the owner can lawfully repossess the property and sell to a third party without recourse to you. So you have to negotiate that thoroughly during the negotiation stage for the agreement before you agree. Very important. So if you've agreed that they can repossess if you default and they repossess, don't go crying wolf. Very important. So you could also negotiate for an extension period, a grace period before they can sell to a third party. You can also negotiate sometimes for an option to actually bring a buyer. These are some of the things that I've dealt with in real life. So very important. If you're a hirer, make sure you get a lawyer. Make sure you negotiate the best terms for yourself. Very important. And also pay attention to the interest rate. Usually hire purchase agreements come with interest rates. So if you're paying over a period of time, There's an interest rate that comes with it. Pay attention to it. Make sure it's something that will not be too much for you in the long run if you're an IRA. And if you're an owner, make sure it's something that's favorable to you as well. So hire purchase is a very important aspect of business dealings and of our life as a people, because for the owner it helps you to sell off your stock and it protects you against deflation. So you know that your good is already out there, paid for, and even though the IRA is still paying in installments, there's an option for them to purchase at the end, and you're still making your money back in installments. So it protects the IRA in the sense that you need to use something. You don't have the money for it. Unlike taking a loan where you need a collateral, you can go get this thing from a owner. You can go get this thing from the dealer, the owner, and you can start using it, especially if it's a tool of trade. You can start using it and making money. So you're paying back for what you could not afford to buy outright, and then you're also continuing your trade, and it protects you against inflation because you're going to pay the agreed sum, not the price that it is at the point, when you have the full amount. So it protects you against inflation, protects the owner against deflation, and it helps both parties in the long run. I think the most important point to bear in mind is that no matter how far you've gone in your payment, if you breach the agreed installment, if an installment falls due and it's unpaid, you can lose everything. So put that in mind and make sure you factor it into the way you negotiate the contract as a hirer. So hire purchase is beneficial for the society, beneficial for the economy, beneficial for owner, beneficial for hirer. Both parties should just know what they're doing and negotiate the best terms for themselves. So it's not an opportunity for you to take goods that you cannot afford in the long run and escape and abscond. No, it's a provision of law, an arrangement under the law to benefit both parties. Both parties should come to the table with clean hands. That's all I have for you in this video. It's a long video. I hope you watched up to this point, and I hope you will check the description box if you need my legal services. I will see you in my very next video. Toodles.